One of our directors formerly left the board of the Charity Law Association at our AGM last night. Matthew Harding, who's chairing the next panel, has stepped down from the board after 12 years as a director of CLAANZ. And CLAANZ really thought it would be good just to recognise the very long and very extensive support that Matthew has provided to CLAANZ over the years, including acting as chair of the association for a number of years. Anne is going to talk in a moment and elaborate a little bit about Matthew's role, but I just thought that I'd thank Matthew as the current chair of CLAANZ very heartily for the support that is provided, and let everyone know that the association is making Matthew a life member. Matthew, if you want to hold up your medal. Thank you, Matthew. Anne, I'll hand over to you.
Thanks very much. There can never be too much bling, I say. But thank you, Matthew. Look, thanks for everybody. We were going to do this last night, but at the dinner it was too noisy, and it wasn't just because of all the talking it was noisy, it was the venue. But anyway, so it's very important to acknowledge and to tell stories. So I'd like to put this in context of what Matthew's been doing on the board. And again, just so that you can be carriers of this story. So you probably know CLAANZ started as ACLA, the Australian Charity Law Association, in 2009. And we set it up in our firm. It started off in our firm. And to be quite honest, we're shamelessly copying the UK version of the Charity Law Association. In fact, I went to their conference a couple of times in London, talked to them about it. They were very happy. They started with the same sort of model. They started being hosted by Bates Wells Braithwaite, which was sort of the leading charity law firm in London. And they're very happy for us to sort of use the same sort of name. And if you're wondering why we changed the name for two reasons. One is because the Australian Commercial Law Association got really offended that we had the same acronym. And then it was opportunistic. We thought we must include New Zealand. It was Sue Barker, the great Sue Barker, has been involved in such a long time. So it was a great opportunity to actually reinvent ourselves as CLAANZ. But I digress. This institution, and it's now a charity, as I told you before, which is important, has represented one of the pivotal arms in getting a reform process in the support of the sector. One of them obviously was going for a regulator that was on a good regulatory regime, but a very important part of these, I see as three pillars, was having the support of a good institution that supported the development of good lawyers in practice, in academia, and in government, actually, the regulator. And why I particularly want to thank Matthew is that Matthew was there very early on, and we started in 2009. We had our first little conference in Sydney that year. The big one was 2010, and that was when Matthew joined the board. So he's been on board, so to speak, since 2010. And for those of you who were there at the time, it was extraordinary. You still remember it like I do. And it was huge. We had 250 people, which was a massive thing, in a Melbourne hotel. And all the Treasury people turned up, the ATO people turned up, and they all sat in the back row because they weren't allowed to talk to anyone. They could hear, their instruction was to hear, but they could not speak. We've come a long way in that time, as you saw today. But so why I want to mention that is Matthew's contribution has been to bring the rigour of the academy, if you like, academic lawyers who are a really important part of building this infrastructure of a community of collegiality and support. And Matthew's done that in a really helpful way by developing that kind of support at Melbourne University. And it's not a given thing. It's not a given thing at all. It's been very hard to get that sort of interest. And he's really stuck his neck out and gone into bat for the sector to get that kind of support. So we want to thank you, not just for the 12 years of being a director and some of those, I can't remember how long, when you took over from me, whatever it was.
4 years as chair.
Something like that, anyway, but very important. But you need to understand the importance of what he's done in bringing the academic perspective on the project. And it's been a wonderful we've bounced off each other, given the opportunity for practitioners to speak to the highly regarded, very expert academics. So we want to, all of us, thank you profoundly for that, and ask you all to continue to carry the flame, be bearers of the flame. But thank you, Matthew.
All right, very briefly from me then in response before I introduce the speakers. And to have those words from you, of all people, means a lot to me. Thank you very much indeed. And Ian, I couldn't think of anyone better to take on the chair from me, and it's just wonderful to see the association going from strength to strength under your leadership. To the directors who've served with me on the board, it's been just one of the great privileges of my professional life so far to have worked closely with each of you. You know the ways in which you've supported and mentored me, and I value our friendships very deeply. And of course, I look forward now to my lifetime of membership. So you'll be seeing more of me, no doubt, in the years to come. It's been a privilege to serve this organisation. Now, to our panel, to talk to us about administrative discretions and the challenges that these give rise to. We have three fabulous presenters here looking at this question from different perspectives. My colleague and dear friend, Associate Professor Jenny Beard, to talk from an academic standpoint, but not only does Jenny bring an academic standpoint to this topic, she also has served as the member of merits review tribunals, both at federal and state levels. And so she brings the wealth of that expertise and experience to this conversation. Of course, Anna Longley from the ACNC, who was introduced this morning, and so I won't introduce her again now, to bring the perspective of the holder of these discretions, the decision maker themselves, and Angela Lee from the Victorian Bar, who has been involved in some of the more significant charity cases in recent years, including Warbra and the Global Citizen case. Angela will be able to bring the perspective of the practitioner assisting in processes around the review and appeal of these decisions. And so without further ado, I'm going to hand over to Jenny, and our speakers will speak in turn, and then we'll take questions and comments at the end. So over to you, Jenny.
Okay, thank you, everyone. I would like to begin by acknowledging again that we are meeting on the unceded lands of the Wurundjeri and Woiwurrung peoples. And I would like to add to Anne's comments, just because I work in the same faculty as Matthew, that the work he has done to promote the learning about charity law in the faculty has been extraordinary. The introduction of subjects and courses around charity law has really made a difference, and his mentoring of me as a colleague in this area of law has also been fabulous. So thank you, Matthew. And thank you, Ian, and to the organisers of this conference as well. Okay, so I like this conference paper because it really is just Administrative Law 101 for me. This is what I do. It's a broad introduction to administrative law for the non-lawyers in the audience, or for those who studied administrative law a very, very long time ago, when it didn't make much sense. For those of you who know administrative law now, you'd understand that it still doesn't make a lot of sense. It's just for different reasons. So what is administrative law? Okay, big picture, administrative law and administrative law institutions have evolved over time in white settler law to ensure that individuals can hold the government or governments to account as it executes and, maintains the Constitution and the laws of the Commonwealth. So that's what the executive does. So we've talked a little bit about what it doesn't do. It doesn't make the laws, we hear, but in fact, it has a very important role to do in maintaining the law and administering the law, and it does in fact make the law as well when Parliament decides to delegate its lawmaking powers to the executive, like it does to the Governor-General in the ACNC Act, then the executive also can make the law. So looked at from a different perspective, we might say that administrative law is concerned to ensure the lawful and efficient exercise of executive functions. And it's not always just individuals, but also governments who can bring cases before the courts to obtain clarity with respect to the exercise of its powers. So administrative law really is a field that covers all branches of government, not just the executive, but we're talking about the executive in particular today. And essentially what it is doing is protecting the rule of law. So all persons and agencies in Australia are, of course, subject to the law, and they must be accountable to the law. So that means that any power, administrative power, that is exercised by the executive must be lawful. It cannot be arbitrary. And that starts to give us then an example of what executive power is. It is authorised or lawful power. So in a moment, Anna is going to outline the kinds of administrative decisions that the ACNC is empowered to make, as well as run through the decision-making process. But in terms of this process, or any statutory decision-making process, administrative decision-making is bound by the preconditions, and this is High Court language now, is bound by the preconditions to, and excuse me, I also have a cough, and the conditions on the exercise of their powers and functions. So in the case of those people working for the ACNC, whether it's the Commissioner, the Commissioner's delegates, or other Commonwealth officers, those preconditions and conditions on the exercise of its power are to be found in the ACNC Act and the associated regulations. And in exercising those statutory powers, there's also a range of implied norms or standards about how those powers should be exercised. So they must be fair and impartial, not irrational or unreasonable, and they must be authorised by the statute and not an improper exercise of power. So all power in Australia is limited by those implied standards when you read an act. But let's think more practically then about what administrative power is. We've all been subject to it for the past 2 years in particular. So what does it really mean? Well, it's woven into our daily lives. But if we take the powers and functions of the ACNC, for example, without the Act and the regulations, everything the ACNC can do nothing. Everything it does stems from the Act and the regulations, not the policies, the Act and the regulations. You might also think about the function of administrative power from a national perspective, of how administrative action shapes our national identity and relations in Australia, including how administrative or executive power shapes the public's perception of charities and charitable work. And the Minister started to speak to that today. So when the ACNC exercises power under the ACNC Act, that is when it performs duties or makes decisions or assists in the making of laws, which will then be signed off by the Governor-General as regulations, the ACNC has the objects of the ACNC Act in mind. Excuse me. But these objects, yeah, thanks. But these objects are a ground of contestation. So at a very general level, this statute and the associated regulations are really important. Most folk working in the charity sector work with policies. They work with bureaucratic forms that have essentially translations of the law and policy. They work with accounting standards. But I think it's really important that you also, from time to time, just go back to the Act and the regulations and read the law. It's supposed to be for everyone. As an Act, it's not impenetrable. And and one of the delights as a teacher is sometimes when I'm telling students this is the interpretation that the High Court took to this Act, and a student will say, oh, but couldn't you interpret it this way? Yes, you could, and that's a really great interpretation, particularly because times have changed. So you should read the Act and think, well, is this decision reasonable, and how does it sit with my interpretation of the language and the words in the Act? Because in the end, when the courts interpret the Act and the regulations, the courts must, as a matter of principle, give an interpretation that accords with the ordinary English language meaning of those words, unless a technical word is used. So I just want to emphasise here that you have to understand that the limits of its lawful statutory authority and what your rights of review are go back to the Act and not the policies. Policy is not law. Policy is guidance on the law. Policies are introduced for a range of fantastic reasons: to ensure consistency of decision making, to ensure accessibility, legal literacy. They are generally used as guidance. The ACNC is quite a small agency, say, compared to the Taxation Department, for example. But you can imagine if you have dozens or hundreds of decision makers all interpreting a single Act, it really helps to have policy so that they're all on the same page when they interpret a single provision or the meaning of a single word. So policies are really good, but they're not the law. And so just keeping that in mind. So what I said is the only way you're going to be able to challenge the effects of the ACNC's actions is to understand the preconditions to and conditions on its power and functions as set out in the ACNC Act and the regulations. Policy isn't law, but it has an important role to play, particularly within the executive branch of government. Okay. Now, in terms of precedent then, if you really want to know what the law is, you have to go to court, not the AAT, because only a court can finally determine what the ACNC's powers are and what the ACNC means as law. And you can only do that if you're a person affected by power, by the way. Angela and Anna are going to talk more about the review of administrative decisions by the AAT and the courts under the ACNC Act. But it's important to note then that main distinction, that the courts can finally determine whether or not a decision is lawful, whether it's been lawfully made and what the law is. But agencies within the executive are there to maintain and administer the law and make delegated legislation. That's not to say, however, that the AAT within the system of government doesn't hold precedential value. Why have a merits review system if it shouldn't be followed? It's there to model good government and to model good government decision making and to model how you apply and interpret the law to a particular set of facts. It does have authority in terms of what the law is, but it's not binding in the sense that it's not the law. It's not the last final determination of what the law is. Okay, so I'll just speak quickly now, but there are different kinds of review under the ACNC Act, as you're probably very well aware. I've put them up here on the slides for you, but essentially there are two avenues of review that can be pursued. One is to the federal court and one is to the AAT. They're quite similar in terms of jurisdiction. So it's a very interesting set of provisions. As an administrative lawyer, it's interesting to see that the federal court has a role at first instance here in terms of review of an objection decision. So the first set of review, of course, is within the Commission. The Commissioner can review a decision that becomes an objection decision, and then you can seek review of that decision either by going to the AAT or by going to the federal court. What is interesting is that the ACNC Act has modified the jurisdiction of the AAT. So the AAT normally would be able to start the decision afresh and look at any facts or grounds that are relevant at the time it makes its decision. But under the ACNC Act, it can only work with the grounds that were before the Commissioner when the Commissioner made the decision. Both panellists will be talking more about some of the more pragmatic issues concerned with seeking that review. But in terms of what happens at the merits review level, if a person is seeking merits review of a decision, say to refuse a charity's registration, the merits reviewer must consider the application for registration again. They can agree with the decision, that is, they can affirm the decision and the decision stands. They can vary the decision. So, for example, if it were a decision with conditions imposed, they might change the decision so that there are no conditions imposed. They can substitute the original decision with their own decision. That decision has to be the correct or preferable decision. And preferable is used here in this phrase because obviously these are discretions and there's not always one correct answer. There could be a range of decisions that could be made. It's the preferable decision and the correct decision according to law. But they can also not make the decision but remit the matter with some directions about how the law is to be interpreted. Again, some precedential value here, or with a direction that one of the criteria is met in a larger decision. So there are a range of remedies, if you like, that are available if you seek merits review. And the courts have essentially a very similar jurisdiction, which again is interesting that the courts have that first instance go, because normally what would, a much more common scenario would be AAT first and then to the federal court, but only on a question of law. So it's an interesting regime that has been inserted into the ACNC. Okay, I think that's all given the time that I will say. As I said, I've put the provisions up there in case we need to talk about them, but I'll hand over now to the next speaker. So thank you, everyone.
I might stay seated for my bit. So I wanted to start with a bit of an overview of the types of decisions that we can make. The ones that have a legislative review right set out there, and I've got internal and external because there are a few that first we go to internal review on, and then after that internal review, we have an objection decision, unless, of course, we change the decision on objection, which we do from time to time. And so then you do have that external review availability. So it's refusal to register as a charity or with a subtype, or revocation of registration. They're probably the big ones that have those review rights. There are other review rights that sit around giving or varying a direction, suspension or removal of a responsible entity, or issue of a penalty as well. But they probably don't come up as often, particularly given we've never suspended or removed a responsible entity. So there's also a few decisions in there that actually have no legislative review rights. And so the position there would be that you cannot actually object to a decision that we make in that respect, particularly say around withholding, etc., or additional reporting requirements. And so this is where we would probably have more of an informal review process. So there could be a complaint in respect of that, and we would consider it through that method. But I think it is important to note that it wouldn't actually be a formal internal review under the legislation. And then, of course, we've got some administrative discretions as well. And they're generally signified by the commissioner may do something. And then there are no review rights that come out of the exercise of those discretions either. And so these are things around changing the due date for charity reporting, or what the record keeping requirements are. And so there are discretions in that sense as well. Now, I have to say, Sally told me to change this slide and then I promptly forgot. So I do not want you to think, it's been a big week. I do not want you to think that there's a notice of intention to review every time we get an application for charity registration. It is absolutely not the case. Sally said, oh, no, I don't think that looks too good. And I went, oh, yes, I'll change it. No, it didn't happen. Sorry.
I'll deal with that.
Okay, thank you. We absolutely don't. And I guess I also wanted to, make the point in this that we spoke yesterday a little bit about, well, actually, Joe from New Zealand actually spoke very helpfully about our triage process that we go through when we're looking at charity registration applications. And so that kind of is informed in this process as well. But I should note that part of this process that we go through, there's the fulsome process in every event, but some of them will be shortened. For instance, if we get an application for charity registration from a recognised religion wanting to register the place of worship, great. It's a pretty fast process. If we get a private ancillary fund that's ticked all those boxes, so 24 hours the team often turns those around in. But if we're looking at some of the more complex decisions, so if we're looking, for instance, at an entity wanting to apply as a health promotion charity, for instance, there's a lot more work that has to go into that. We actually have to review what the activities are. We have to have a bit of a different look at that. And that's when that process can be a little bit longer. So we get in an application, and some of you will know that we're reviewing our application form at the moment, which has been a really great process working with a lot of people across the sector, so that hopefully we get a little bit more information at the outset. It's always this balancing act. We have to get enough information, but we don't want to ask too much, but we don't want to come back to you 10 times and ask for more, because that's really annoying for the charity. And so we get the accompanying evidence in. We'll have a look when we're reviewing it for public information. So what can we see about that charity or that entity out in the public domain? And there may or may not be a request for information. We then will receive that back, or we'll have reviewed, and maybe it's a decision to register an entity with the subtype they applied for. Fantastic, everybody's happy. My favourite day. But sometimes we might get that information back and think, we're not quite sure. We're not quite sure that this is the way that we would, or we don't think this is maybe an entity that we would register as a charity or with this subtype. And often when we send out the notice of intention to refuse, the position or the intention, even though it's headed a very specific way, so I know there's some issues maybe with the title of it, but the idea of it is to set out very clearly what our views are in a way that enables an entity to respond to the concerns. And there are many occasions where we get a response to that, register the entity. So there's another pathway to registration as well. But what it's allowed the entity to do is really have a think about what it is that our concerns are. And the same is true of, say, a show cause notice if we're looking at revocation, which I've deliberately not gone through the process of because we'll get sidetracked by all the things. So we're also looking where we can hold discussions in this process as well. So there might be just a little bit more information we need, but maybe in writing's not getting it out. So I am encouraging all the staff, and Sally and I attend some of these meetings as well. Let's talk to the entity. Let's understand exactly what it is that they're doing and what they're trying to achieve. And so then that's when we might, again, register, or we might get to a point where we decide that we make a decision to refuse. And so the complexity of the application is really important, as I said. And also, I guess when we get to this decision, as Jenny's spoken about, we make a decision under an authorisation. A decision to register is generally made under an authorisation, which means the staff have the authorisation to make that decision to register. Decisions to refuse or decisions to revoke registration sit with the delegate, and so that's either the commissioner or the assistant commissioner. One of the reasons that it does still sit with the delegate is that we think it's really important, because those decisions really affect the entitlements of entities, and we really want to make sure that all of those decisions are very strongly considered. So we look at that through the lens of, if we're talking about revocation, the preference always towards advice and guidance, and revocation as a last resort, or any of our other enforcement powers. Natural justice, procedural fairness. We also look to be supported by the policies that we have in place, again, recognising and agreeing completely with Jenny that all the power comes from the law, though. So I think also it's interesting to note in this one as well, when we think about the decisions that say in this application context we don't approve. In the last year, so up to 30 June 2022, we processed over 6,000 charity registration applications. We registered 300. No, we didn't. That's terrible. 3,152. That's very different charities. But a number of those that we've received were reapplications. And also, of the difference between the 6,000 and the just over 3,000, the bulk of those are withdrawn and closed as incomplete. So that's where we will try to work with a charity or an entity. In most instances, they will go away, they'll think about it again, they'll come back, and that's why we get so many reapplications as well. It's up about 2,000 a year that we get. So it's actually only a very relatively small number that were refused. So I might leave it there and hand over to Angela. Thanks.
Good afternoon, everyone. So what I'd like to do is to discuss how ACNC decisions can be challenged from a practical perspective. There are three phases to the process. So the first is what I would call the original decision. So on Anna's slide there, we're probably hitting quite a number of the original decisions, if you will. So applying for something, getting reviewed and having something done to you, notice of intention to refuse, etc. So that's the original decision. If that's adverse, you can, as Anna explained, as an internal process, seek a review by objecting to that original decision. So that's called the objection process, and the outcome of that is an objection decision. And that's the decision that's going to be the subject of a review or appeal in the AAT or the federal court. Now, pausing there and recognising the confusion in the terminology, the legislation talks about review in the AAT, appeal in the federal court. They're both first instance steps in stage 3. So I'll ditch that terminology from now on. I'll just say go to AAT and go to federal court. The reason is when I use review, I want to talk about the ACNC's review of an entity. And when I use appeal, I want to talk about an appeal of the first instance decision. So if you go to court or tribunal and you get a decision you don't like, you can actually appeal it, and that's something Anna and I will talk about. But I will ditch that terminology to focus on this part of the process. to help make this discussion a little bit more concrete, I'm going to use the first example that appeared on Jenny's slide 4, and it referred to a refusal to register based on what the entity saw as the wrong facts or the ACNC being unreasonable. And as Anna has just mentioned, it's actually not an uncommon situation that entities might find themselves in. So the scenario would be that the entity applied for registration as a charity and got knocked back, objected, but the objection was disallowed. So what's next? That's where I'm picking up from. Now, I see a number of friendly faces and colleagues in the room that have been through this process with me, so I do invite you to jump in anytime if you've got comments or suggestions or anything you'd like to add. It's certainly team building, I would say, in the process. Okay, so the first thing you do is you need to pick a forum. So you need to go to AAT or the federal courts, as Jenny has outlined. I'll probably refer to the entity as the entity or the applicants. It's actually the entity that takes the ACNC to court. ACNC doesn't take you to court to start. And I don't necessarily want to use the word charity because that's exactly the subject matter in dispute, whether you're a charity. Okay, so both Jenny and Anna, and also in earlier discussions today, we've talked about the difference in nature between an AAT decision and a federal court decision. And they're all really valid and important points. I'm going to ask you to toss it out the window, because when you are the entity that's trying to challenge an ACNC decision to not register you, you're not in the process to try to improve the body of jurisprudence. You want your registration. The outcome's the same either way. So I wouldn't put that as a key factor. I think the key factor of concern, and again, it's come up throughout the day, is costs. Now, it's going to cost money for each party to run their case. That's your own costs. A key difference in this context between the two jurisdictions, if you will, is the loser in the federal court generally has to pay the winner's costs. So that's double whammy. I'm talking about an entity that wants to register as a charity, is unsuccessful in the federal court, so no registration as a charity, and pays the other side's costs. And that's the uncertainty, in addition to paying one's own costs, can be a huge burden and disincentive. So when an entity themselves want to register, at least they can try to manage their own costs, but then to have that added component can be a real difficulty for them. I think, so it's been mentioned before, the Australian for Indigenous Constitutional Recognition. In that case, the entity sought orders from the federal court. So they applied at first instance to the federal court and they sought cost orders, in essence, to try to mimic the cost arrangements in the AAT, and that was not allowed. And I think, as it was discussed earlier, the implication may well be that an entity that's adverse to cost risk should probably look at starting in the AAT rather than going straight to the federal court and seeking cost orders as this entity did. Some key differences that may be worth noting when one has to choose between the AAT and the federal court. The AAT is generally seen as less formal than the federal court. I think in practical terms, you might get a little bit more leeway on the timetabling, maybe, and rules of evidence are different. So federal court is subject to the rules of evidence. The AAT is not. It can inform itself as it sees fit, subject to natural justice. That's a lot of words. It generally, in practice, it's about the same, really. But I find you get a little bit more flexibility. I find you can more easily get evidence in the AAT than the federal, as in admissibility-wise, you can get it in. After that, you argue weights until the cows come home. So it may well be that nothing turns on these points. Another thing that you might want to keep in mind is if it's a controversial issue that's pushing a new frontier in the law, the appeal process might be slightly shorter under the federal court. There may be one less step, but on the right case, this could be managed. So I wouldn't let that be the determinative factor. You certainly would keep it in mind. So after all of that, I would say it's fairly similar in terms of the work involved, the costs involved in running it in either jurisdiction. I don't think there's a material difference between them. And I understand from reported cases that charity law ACNC cases tend to be filed in the AAT. I want to talk a little bit about timeframes. 60 days from receiving the adverse objection decision to commence proceedings in either the AAT or the federal court. The commencing the proceedings themselves, I guiltily say this as a barrister because my instructing solicitors normally look after this step. It's not overly burdensome. But you fill out a form, put in a notice, pay some fees. It's, you know, I hope it's in fairness for me to say that in the whole scheme of things, that is not going to be the thing that's going to tip anyone over. But I say that with a full confession that I don't do that myself. So once the parties are in court, though, it's really important to remember that until now, the parties have had a significant say over the timing of things. If you need another extension to prepare some material for the ACNC, you could ask for that. If the ACNC needed more time, they could discuss that with the entity. But once you've filed, once you're in court or the AAT, you're in their hands, you're in their timetable. Now, that doesn't mean there's no flexibility. It just means you're no longer in control. And it's worth noting that. And sometimes you get a judge or an AAT member that's going to put you on this rapid fire of a timetable, and others are more accommodating. So just be very wary of that and be prepared, get ready for the case. So what do I mean by get ready? So let me just explain the scenario to you. So the hypothetical example I'm using is that you're going to the AAT on a declined application to register. The role of the AAT is to step into the shoes of the ACNC and decide again on the evidence before it whether that entity should be entitled to register. So as Jenny discussed, it's to make the correct or preferable decision. The entity can submit more documents. It's not limited to what the ACNC saw. And importantly, in the example that Jenny set up, the points about thinking that the ACNC has misunderstood the facts or was acting unreasonably or the like, that's out the window now. Don't worry about that. We're starting from afresh. So clients in particular can get quite frustrated by stage 3 because they're saying it for the 3rd time, and they are. And you're on the right track. So you say it the first time at application, you say it again on objection, you say it for the 3rd time. Don't lose heart, stay at it. You're telling a different audience now, they're hearing it for the 1st time. So don't think whatever you've told the ACNC usually months or years ago, don't think that that's necessarily front and centre for the AAT. You need to tell them fresh. And if it's a point of emphasis, tell them that. Say it to them fresh. Now, Jenny mentioned the burden of proof in her slides. This is critical. A lot of my work is done on meeting this burden. The burden falls on the applicants, being the entity wishing to be registered as a charity. So by way of example, I'm just going to pick the first items. So subtype number 1 is advancing health, as we all know. And the applicant would need to prove, and that's on the balance of probabilities, that its purpose is to advance health. Now, we know that purpose is determined from history, objects, and activities. So some decisions will need to be made now. Who's going to speak to history? Who's going to speak to objects? Now, objects may be quite self-evident because you can just produce the constitution, but sometimes there have been changes in the objects, and sometimes objects are changed around the time of an application. That needs to be explained. The tribunal will want to know why they were changed. And I find activities is probably the most challenging component. Someone needs to speak to activities, finances, employees, how they spend their time, volunteer involvement, any changes over time. Now, we need someone who has the requisite knowledge, but speaking as a litigator, we also need someone who can stay pretty calm under cross-examination. So we need the right person to give that evidence, and that's part of the strategy of putting a case together. The evidence is typically in the form of a witness statement or an affidavit with exhibits in support. So you might have annual reports, financial statements, strategic plans, etc., to accompany it. By way of example, you can bring yourself back to the time when you're applying, you're putting in your application, and you might do a little table for the ACNC that says activity in one column and percentage of time in the second column. It adds up neatly to 100%, and you send that in and you think, great. I'll need to invite you to rethink all of that, okay? Now, how did you identify the classes of activities? How did you come to your percentages? What source material did you use? And how did you, what period? We need to explain all of that in your affidavit. And that's going to be subject to, you'll be open to cross-examination and also potentially questions from the bench. That's also possible. So what I'm saying really is you might just have to dial up the quality of the evidence because you carry the burden and you must meet the burden, otherwise you fail. So that's why it's really important to go through all these steps. This little example, then multiply to every other point that's in disputes. Now, it's usually, as you can imagine, quite a labour-intensive task. You'll need to allow sufficient resources, time, costs, etc., to prepare for it. And even with the involvement of a legal team, usually, I don't want to sugarcoat this, a substantial amount of input is required from each witness. It is their statement. We only help put it together. And it does take time away from their day jobs. So this needs to be factored in. So that's the evidence side. I'll go quickly on the submissions and sort of procedural side. The legal team can lead much better on the submissions and sort of procedural side. Usually a point of contact is nominated by the entity, by the applicant, to act as, first port of call and also to give instructions. So again, that whatever role that person normally has as a day job, you've got to add this on top. Once all that goes in, typically once that goes in, then there may be mediation or conciliation, if appropriate. If it's the parties are just too far apart, there's no point spending the resources that way. It may be ordered by the tribunal. All sorts of things can happen. As I said, it's no longer in the parties' hands. You put it into the tribunal's hands. And if the matter doesn't resolve, you go to hearing. Need to allow for the witnesses to be available for cross-examination, and also for the key contact person I mentioned, they'll probably need to be there all the way through to for the hearing and to give instructions. And then after the hearing, the parties, of course, then wait for the decision to come out. Now, Anna, you're going to speak a little bit more about appeals, or? Okay, yeah, that's okay. In the event the decision of the tribunal is adverse, then the party can appeal the decision. The appeal is limited to a question of law. So it's important to think ahead when you're preparing the tribunal case to get all your facts in, because it's much harder to get facts in on appeals at the appeal stage. Appeal can then be appealed, the appeal can then be appealed, goes all the way to the High Court potentially. And it's important to remember that the most recent decision will remain in force pending the outcome of any subsequent appeal. So if you start off not being a charity, you're not a charity until someone finds you a charity, and that stays in place until there's a successful appeal by the other side, if there is one. So what I might do is just circle back to the stages 1 and 2 that I talked about. Like, in light of this process in stage 3, which I'll call the litigation phase, what can we take away from there when we go look at stages 1 and 2? My first tip would be what I call front-ending the work. What I mean by that is what you want is registration as a charity. Don't hold a smoking gun for later. Get your best evidence in and get it in the best way early, because that might avoid the subsequent stages, each of which costs time and money. And by getting the best evidence in together, you may work with the ACNC to narrow the issues in dispute, or better still, resolve the dispute. So Anna, in her earlier session today, talked about pinpointing differences. This is how I see one way of applying it. So of course, parties can have different views. That's completely normal. That's how the legal world works. But the earlier you can actually hone in on what the differences are and what you need to go and fight about, and then focus your efforts and energy on that, it's better than just fighting everything under the sun. my second tip would be the grounds of objections that Jenny has very helpfully mentioned earlier. Again, always preparing for the next step. One of the key roles of objection is to get your grounds in, because if you don't, then when you go to litigation, you're limited to those grounds unless you get special permission to expand them. So, and that's a step you probably don't want to invite if you can avoid it. So get your grounds in at that stage. Make sure that it's what you want to argue on later, should that become necessary. I want to just mention briefly, Jenny talked about policy. So as an advocate, I work for either side, whoever wants to brief me. And we sometimes look at interpretive statements, for example. So policies, interpretive statements and the like. Can I be a little bit cheeky and say, use it if it helps you. And if it doesn't help you, it's the other side's view of the matter. So that's really all I wanted to say at this stage. So I might hand back over to Matthew.
Sure.
Oh, I was just going to, oh, sorry, yeah. I was only just going to take a second with it, but I just did want to point out around decisions to appeal. So this is if there's been a decision in the AAT, the kind of considerations that the Commissioner would take into account in seeking to appeal. As Angela's already said, we need a question of law, so that's kind of number one. But also for us, we operate under the model litigant guidelines, which I was reminded of weekly when I was at the ATO. And so that's really, it really is important, and it helps to guide us in our thinking around appeals. There are quite a few standards that are set out there, or obligations. But the ones that I just wanted to point out is in relation to reasonable prospects of success, and also justifying in the public interest. And so they're considerations that we take very, very seriously. We actually have to report on some of this as well. And so I just wanted to point that out, that we do have these other considerations when we appeal, and I guess, or if we decide to appeal. And I guess in that vein, the other point that I guess Angela made really clear is when you are an applicant or an entity, you have the relative luxury, in a way, of arguing whatever you like. We don't do that. We argue on the basis of principle and having regard to the broader, I guess, administrative realm in which we operate. So we're not just thinking of the particular case in front of us. We're thinking, well, what is it that can come out of this case that can help us administratively, and what will help us to get some really clear meaning on this. And so I just wanted to make those points as well, because we do sometimes come at that litigation element from a slightly different angle. And I should also note that we have those discussions also at first instance and also at objection stage. You know, what do we want to get out of this? Is this the right setting for not just this entity, but the other entities that will be coming to us as well?
Thank you. Okay, so the floor is open. Questions up the back? We've got a hand up already.
Thank you, everyone. Just a question for Angela. It's Harriet Wallershill from Wallows Legal, by the way. I just wanted to clarify my understanding with regard to what you're talking about with charity status and how it can be, I guess, an entity can be a charity and then not a charity, depending on where you sit in the litigation, what stage of litigation you sit at. I just want to clarify my understanding that that applies usually from the date that those objects were adopted by that entity, and on that basis from that time. So say an entity is created on the 1st of August 2022 and it adopts objects, and then the argument is whether it's a charity or not. When there's a decision that it is a charity, then that applies from the 1st of August 2022, and when it's decided that it isn't a charity, then does that mean that it applies retrospectively as well? Am I making sense?
Can I take a moment to phone a friend? I need to ask a technical question. Is there a date of effect on the form? Like,
Yes.
yeah, okay.
You apply from a date.
Can I
Yeah.
give that part to you, and I'll talk about what I was.
Okay,
Can we split the answer? So what I was talking about was the case study I tried to round my section on is about an entity wishing to apply to become a charity under the ACNC Act. So what I meant by what I said was, if you apply and it got knocked back, and you object and that got knocked back, and then you go to litigation, until someone rules that you are a charity, you're not. So that was my point. Your point, as I understand it, is about date of effect, which is an opportune time for me to hand over to Anna.
So generally on the application form, entities will tell us the date from which they want to be registered. And so that is generally the date that it would apply. Although, you know, as we said, the tribunal can make a different decision if it wants to. It may actually decide there is a different date from which registration applies. But I would say normally, in the normal course, it would be the date from which the entity sought registration.
Just because I guess it's a danger there that if someone, sorry, I hope I'm not holding everyone up and this is a boring question for everyone else, but it's something I get asked a lot. But just if you are going to, say if you've your status has been appealed by the ACNC and you risk losing charity status, I just want to be aware, clear in my own mind that I should be, which is what I do, telling my clients to be careful not to be taking, say, for example, funding on the basis that they're a charity, because if they lose that status, then it has implications for the people giving over that funding.
Yeah, unfortunately, yeah, I do think it is a risk while there's ongoing litigation. Yeah. Yeah.
Anyone online? Yeah, Bridget.
My question is for you, Angela. I'll just speak up. Well, I can speak loudly. Angela, you talked at the end there. Well, the first thing to say is Angela Lee is the most amazing barrister to work with ever.
Check is in the mail.
Second thing I want to ask is, you talked about getting your grounds right, because when you go to the AAT, you can only appeal on those specific grounds. It came out of Waubra. When we worked together, I found that quite difficult to get my head around, because Jessica and I had written these objection decisions and not objection decisions. That was
Yeah, we're doing DIY now.
We've written these submissions to the ACNC and really clearly laid out why we thought a particular answer should be reached. But when we came to you, you said, look, the ground here, Bridge, is none of that. It's just we are entitled to be a insert charity subtype. Can you just explain that? Maybe that's helpful to the room. Like, what is the grounds issue there?
Yeah, so the ground is, I guess, one way to look at it is like what you say the ACNC got wrong in refusing your application. So what's the question they need to answer in your favour, as opposed to the submissions or each proposition supporting why you say that outcome should be, is the correct or preferable answer. Yeah. So in practice, what happens is you go wide on the grounds of, don't quote me on this. So you go
More objection people.
I know. It's to avoid the whole leave situation. Is you try to set it, you cast it broadly, and what you do is we say you don't press it. so you might like I don't know, you might have 3 or 5 or whatever, but you're really pressing 1 or 2, and the submissions should be quite clear. But I'm assuming the ACNC understands when they receive the grounds that this is a statutory obligation on the applicant. Yes. That the grounds are limited. Yeah. So we're not trying only to be annoying, but we are trying to protect our position, and you try to be smart about your resources when you look at which grounds to press. Mm-hmm. And hopefully that becomes, if it's done properly, it should be quite clear. So you protect your position without wasting resources.
Yeah.
Yeah. I'm going to get disbarred for saying that.
It's a closed room.
Yeah, that's
apart
right.
From Zoom.
Retrospective Chatham House rules.
The recordings are being publicly put up.
Do you need a lecturer?
You're already doing that. Any other questions or comments? Yeah, go for it, Bridget. Yeah, you might as well. Yep.
I'm interested in the admin law side of things, and I know my colleagues in the room as well. We often talk about actually challenging an ACNC decision on, you know, it was unreasonable or whatever it was, but you've got a much shorter time frame. You've got to go to the federal court. So the prospects of being able to do that with a client are slim to none, really. You would have had to have been pre-prepared before the decision to have the board of the charity or entity on board to go with all the funds, not whether or not you have pro bono counsel for them. What can we do in this situation? Are there any other fields in which it's the same? Because the access to justice is minimal in this environment.
Doesn't work either.
No, unfortunately.
I'm just interested in what you said, that the only way to do that is to go straight to the federal, or choose the federal court. But of course, if you sought merits review in the AAT, or it's not full merits review, but a review in the AAT, that would cure any of those aspects of a decision, because they're making the correct decision again and the preferable decision again. So, but then that doesn't, it still costs time and money to go to the AAT, because even though its objects say it's an informal process, you're still retaining counsel and solicitors and what have you to represent you there, and it's still expensive. That goes back, I think, to the broader question of good governance and agencies. I mean, it's great to hear, it's great that there are regulators in this room now, and it's great to hear regulators speak about the ethics of being a public servant in Australia. And it's really, I think that's a question for the regulator about their culture and their ability to make good decisions. You do have that internal review, but it sounds to me, listening to Anna, for example, that often there's a lot of to and fro back between the agency and the entity before an objection decision is made, and then when an objection decision is made. I mean, but it sounds again that
it's less about, I suppose, the merits review and more about this is a legal question, that there's an administrative law issue here, not about the merits of it. And so we want to go and challenge that. And so you're saying go and do that at the Administrative Appeals Tribunal?
Yeah, because they have to, I mean, speaking from my own experience, I didn't work in this jurisdiction, but I was making decisions in the migration jurisdiction, and I am making decisions in the gun licensing jurisdiction. And you see a lot of unreasonable decisions, and doesn't matter whether they're unreasonable. I don't even have to read the reasons for decision. When you're a merits reviewer, you make your own decision by applying the law to the facts, and you try and do it with integrity and impartiality. So yeah, AAT, I wouldn't be going to the federal court to solve a question about a traditional judicial review grounds decision, unless it relates to one of those decisions that can't be reviewed. And then you would have to rely on the inherent jurisdiction of the federal court. I would still be going the AAT route, as Angela, for all the reasons Angela spoke about. Yeah, that's a good question. Yeah.
Very briefly, Elizabeth, and then we'll end the session.
Thank you, Matt, to all of the panel. Also interesting. I guess my question was to you, Jenny, around the admin law grounds, and a lot of the discussion's been around decisions of charity registration or not. But I guess the thing I'm thinking about is the governance standards and the external conduct standards. There's a lot of scope for how they may or may not be interpreted, but the thresholds under the Act, I would suggest, are very low. It's the Commissioner must reasonably believe that there is a breach or likely to be a breach, and how we read that in the context of, you know, what you've described as the implied and underlying administrative law principles about reasonableness and just how they fit together. Because I think the administrative law stuff to me comes to mind in that context where you've got very, very broad powers, what is expressed statutorily to be quite a low threshold for exercising them, and the nature of the standards themselves are yet to be interpreted with a binding legal guidance. What's a perceived conflict of interest? What's some of the external conduct standard stuff. There's so much in that around what are reasonable steps. There's a lot sitting there. So if you wanted to comment on statutory and how it fits with the general admin law principles, given the low threshold.
I think you can see why I kept my example to an application for that very reason, Elizabeth.
Yeah, look, I mean, it's a very, very high threshold to meet to be able to demonstrate that a decision was irrational or unreasonable. And so it's a question of law. So it's not whether, the reasonable person on the, not just, it really needs to stand out as, I'm sorry, it's difficult because it's a philosophical question about lawmakers as well, because it will depend on the judge and their own ideology and what they think is reasonable and unreasonable or rational or irrational. And you see that in the High Court cases where different judges will find a decision rational or irrational, or the factual inferences that are drawn to be rational or irrational, just based on whether they come from I think that the difference is whether they come from a government background and a pragmatic utilitarian background, or whether they come from a dignitarian individual rights perspective. And so that's not helpful, I'm sorry, to you, but it really is difficult to challenge those sorts of broad discretions or broad conceptual concepts for that reason. So sorry, I can't help.
We're all legal realists at heart. Guys, that was just an extraordinary hour. Thank you very much, each one of you.